See the album Once Upon a Time in Shaolin by the Wu Tang Clan. So it turns out that Martin Shkreli is not done with the Department of Justice. The prosecution writes to Judge Matsumoto, "Dear Judge Matsumoto, the United States respectfully submits this letter, along with the attached summary charts and declaration of FBI Special Agent Sean Sweeney, dated November 30th, 2017, the declaration, in support of its post-trial motion for forfeiture against the convict defendant Martin Shkreli. By this motion, the government seeks forfeiture of the following amounts: $3 million based on Shkreli's conviction on count 3, securities fraud; $3.4 million based on Shkreli's conviction on count 6, securities fraud; and $960,000 based on Shkreli's conviction on count 8, conspiracy to commit securities fraud. The court should hold Shkreli financially accountable for his criminal conduct by requiring him to forfeit the amounts above, which total $7.4 million, and enter a forfeiture money judgment against him in that total amount. As set forth herein, this total amount represents a conservative computation of the proceeds Shkreli personally obtained as a result of his 3 different securities fraud crimes of conviction. Furthermore, the government seeks forfeiture of certain substitute assets of Shkreli in order to partially satisfy the forfeiture money judgment. For the court's convenience, a proposed preliminary order of forfeiture is also included with this submission, which the United States respectfully requests be entered by the court. On or about June 3rd, a superseding indictment against Shkreli was returned, which included criminal forfeiture allegations. On August 4th, following a 6-week trial, Shkreli was convicted of counts 3, 6, and 8. Before the jury deliberated on the substantive criminal charges, the parties stipulated to waive any right to a jury and have the forfeiture allegations determined by the court. Rule 32.2 of the Federal Rules of Criminal Procedure govern the criminal forfeiture sought by the government in this case, in pertinent part, as soon as practicable after a verdict of guilty on any count in an indictment regarding which criminal forfeiture is sought, the court must determine what property is subject to forfeiture under the applicable statute. If the government seeks forfeiture of specific property, the court must determine whether the government has established the requisite nexus between the property and the offense. If the government seeks a personal money judgment, the court must determine the amount of money the defendant will be ordered to pay. Further, in pertinent part, Rule 32.2b1b provides the court's determination may be based on evidence already in the record and on any additional evidence or information submitted by the parties and accepted by the court as relevant and reliable. Here, the government seeks forfeiture pursuant to the following forfeiture statutes: 18 U.S.C. 981, 28 U.S.C. 2461, and 21 U.S.C. 853. Title 18 U.S.C. 981 specifically provides for forfeiture of any real personal or personal property which constitutes or is derived from the proceeds traceable to any offense constituting specified unlawful activity, or a conspiracy to commit such offense. Fraud in the sale of securities or conspiracy to commit securities fraud are each unlawful activities as defined by the statute. Further, the Second Circuit has held in the context of insider trading security fraud cases, the applicable definition of proceeds is set forth in 981 as follows: in cases involving lawful goods or lawful services that are sold or provided in an illegal manner, the term proceeds means the amount of money acquired through the illegal transactions resulting in the forfeiture, less the direct costs incurred in providing the goods or services. In contrast to the guilt phase of the criminal trial, the government bears the burden of proof of establishing the amount of money subject to forfeiture only by preponderance of the evidence. So, different standard of proof for the government when it comes to a forfeiture versus a criminal conviction. It's no longer beyond a reasonable doubt. Now it's preponderance of the evidence, which I liken to a tug of war at the 50-yard line, and whoever gets the center of the rope into their side of the field wins. It's no longer it's no longer an end zone after 50 yards. It's the whole thing is the end zone. So it's just a tug of war at the 50-yard line, basically. No one has to seriously convince the court beyond a reasonable doubt. It's just convincing the court beyond the opposing side's presentation. The government is not required to provide a precise calculation of the amount of money a defendant must forfeit. In this case, the trial testimony and exhibits established that during the relevant periods of Shkreli's security fraud schemes, Shkreli himself had control of and accessed millions of dollars. As the majority of federal courts have held, a defendant must forfeit those funds he would not have had but for his criminal offenses. As noted above, Shkreli's forfeiture liability should be a total of the following amounts that Shkreli obtained: the amount of funds invested by defrauded investors, MSMB Capital, MSMB Healthcare, and the funds generated from the Retrofin unrestricted shares transferred to defrauded investors. Each of these components is discussed in detail. We're going to skip this part. Valuation of shares, forfeiture of substitute assets. This is what everybody wants to see here. Pursuant to Federal Rule of Criminal Procedure 32.2e and 21 U.S.C. 853p, the government is entitled to seek the forfeiture of substitute assets from Shkreli up to the value of any forfeiture money judgment that may be imposed. As set forth in the accompanying declaration, diligent efforts have been made to locate traceable assets of Shkreli's security fraud crimes without success. Accordingly, the conditions for forfeiting substitute assets as set forth in the law have been met. Further, as set forth in the accompanying declaration, now that Shkreli has been convicted, substitute assets of his have been located and should be applied to partially satisfy the forfeiture money judgment. Specifically, the following substitute assets owned by Shkreli have to date been identified, and now that Shkreli has been convicted, the court should direct that they be forfeited to the United States in partial satisfaction of his forfeiture money judgment. A. $5 million in cash that is currently held in an E-Trade brokerage account ending in digits 0258 as security for Shkreli's bond. B. Shkreli's interest in and the monetary value of any and all shares held in an entity called Turing Pharmaceuticals. So all of his interest in Turing Pharmaceuticals. C. The album Once Upon a Time in Shaolin by the Wu Tang Clan, as well as any proceeds derived from the sale of such album. D. The album The Carter 5 by Lil Wayne, as well as any proceeds derived from the sale of such album. E. An Enigma machine, as well as the proceeds derived from the sale of such machine. And F. A Picasso painting, as well as any proceeds derived from the sale of such painting. Preservation of assets is necessary in order to ensure that the forfeiture money judgment is collectible and satisfied by Shkreli, and pursuant to this court broad authority under Federal Rule Criminal Procedure 32.2 B3. United States respectfully requests that the proposed preliminary order of forfeiture also include provisions to ensure that the value of the substitute assets and any funds to satisfy the forfeiture judgment are preserved for criminal forfeiture and pending any appeal. Asset preservation is particularly critical in this case now that Shkreli has been convicted and the United States seeks a significant forfeiture money judgment against him. Conclusion. For the reasons set forth below, the government respectfully requests that the court impose against defendant Shkreli a forfeiture money judgment in the amount of $7.4 million. Further, in partial satisfaction, the government respectfully requests the court order Shkreli to forfeit the substitute assets listed. The government respectfully requests that the enclosed proposed preliminary order of forfeiture be entered and attached to his judgment and conviction pursuant to the law. Respectfully submitted, Bridget M. Rode, Acting United States Attorney. What do you think of that? So he has an Enigma machine as well as two albums and a Picasso painting. So he thought he was such hot shit. It turns out it's just a big liar.